This Honorable Assembly has now resumed its sitting. Please be seated.
Personal explanations?
None.
Obituary and other ceremonial speeches?
Honorable members of the House, the House takes note of the passing of Mr. Donahue at minutes before 2 p.m. today. Uncle of the Honorable Minister of Commerce and a respectable businessman in these islands. We, on behalf of everyone, every member, offer our sincere condolences to Mr. Donahue, his brother, and all his family here in the Cayman Islands and overseas. Funeral arrangements will be announced at a later date. Same family. Same family. Yeah. The member from Georgetown Central.
Thank you, Mr. Speaker. Allow me a few seconds just to take an opportunity to celebrate and wish a happy birthday to a former member of this Honorable House, Dr. Steve Tomlinson, who was elected here in 1992 to 1996 for Georgetown, and who is also an awardee of the member of the British Empire by Queen Elizabeth. And I think it would be also appropriate to wish you a happy anniversary yourself for 34 years being a part of this assembly. As to what I heard earlier today, to the date, November the 14th, 1984, you were elected for the first time. So I wish you a happy 34 years anniversary for being elected in this honorable house as the grandfather.
Thank you. A labor of love, a labor of love. Not yet.
Raising a matter of privileges?
None.
Government business. Bills? First readings. The Stalking Civil Jurisdiction Bill 2018.
Before we move to government bills, I have apology from Mr. Miller, the Leader of the Opposition, who will be absent for a few days, tendering his apologies and advising that Mr. Saku, the member from Newlands, will be acting Leader of the Opposition.
Read it again. Read it again. Okay. The Stalking Civil Jurisdiction Bill 2018. First reading. Yeah, you got it? You got it? Okay.
The bill has been deemed to have been read the first time and is set down for the second reading.
Yes. The Penal Code Amendment Number 2 Bill 2018.
The bill has been deemed to have been read the first time and is set down for the second reading.
The Proceeds of Crime Amendment Bill 2018.
The bill has been deemed to have been read the first time, set down for the second reading.
The Legal Associations Miscellaneous Amendment Bill 2018.
The bill has been deemed to have been read a first time and is set down for the second reading.
The Evidence Amendment Bill 2018.
The bill has been deemed to have been read a first time and is set down for the second reading.
The Freedom of Information Amendment Bill 2018.
The bill has been deemed to have been read a first time and is set down for the second reading.
Second readings. The Stalking Civil Jurisdiction Bill 2018.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg leave of this honorable House to move the second reading of the bill, the long title of which is a bill for a law to provide protection and remedies in cases involving stalking, to establish an investigative and complaints procedure in relation to allegations of stalking and for incidental and connected purposes.
The bill has been duly moved. Is the Honorable mover wishing to
Yes,
speak
Mr.
thereto?
Speaker. Thank you. Yes. Guaranteed. Guaranteed. I'll negotiate it for you. Thank you, Mr. Speaker. Mr. Speaker, the purpose of this piece of legislation, the short title of which is the Stalking Civil Jurisdiction Bill 2018, is to establish a legal framework which is intended, Mr. Speaker, to respond to the civil issues involving stalking. I do intend, however, Mr. Speaker, to speak later on to another companion bill, which is the Penal Code Amendment number 2, Bill 2018, which will be dealing, Mr. Speaker, with the criminal aspect of this matter, of this issue. Mr. Speaker, it would be helpful if I were to begin by putting into perspective the type of conduct to which reference is being made in these legislative proposals. Stalking, Mr. Speaker, can be viewed as a series of acts or course of conduct directed towards any person that, when taken together over a period of time, causes that person to feel harassed, alarmed, distressed, or intimidated, and also to fear for his or her safety or the safety of others known to that person. This type of conduct, Mr. Speaker, may escalate from what may initially be annoying and alarming, but lawful behavior, to levels of dangerous, violent, and potentially sometimes fatal conduct. Mr. Speaker, the methods employed by stalkers can involve a series of unlawful actions, such as, Mr. Speaker, making obscene telephone calls, using threatening language, harassment, and committing acts of violence, Mr. Speaker. In fact, Mr. Speaker, recent judicial pronouncements pointed to the need for this type of legislation to properly address the facts. I'm sorry, Mr. Speaker. We are aware of a recent case, Mr. Speaker, which justified the need for this type of legislation. Mr. Speaker, there was a matter before the court where a young woman complained that she was being harassed by an ex-boyfriend who had followed her to the Cayman Islands all the way from Canada. The gentleman or the perpetrator moved into the same apartment complex and started showing up at the victim's workplace, Mr. Speaker. He then began to send numerous text messages from multiple phones and social media accounts. It was on this basis, Mr. Speaker, that the authorities acquired the necessary evidence to prosecute the gentleman, if you recall, where he was charged for harassment. Mr. Speaker, while stalking is gender-neutral behavior, I think we can all agree that women are usually the primary victims and men are often the primary perpetrators. Some perpetrators, Mr. Speaker, may be suffering from minor psychiatric and emotional illness, while others may be suffering simply from what is called a serious psychological syndrome or psychiatric breakdown, calling for other types of intervention. Mr. Speaker, these proposals are not an overnight formulation. They have their genesis, that is the proposal to deal with the bill, Mr. Speaker, has its genesis going back from 2005, when the issues surrounding stalking formed the basis of a discussion undertaken at the time by the Young Business and Professional Women's Club, which, Mr. Speaker, established a task force back in 2005 to investigate the issue of stalking and to make recommendations for legislative changes to address the issue. Mr. Speaker, the Young Business and Professional Women's Club prepared a report dealing with what they termed the prevalence of stalking, and it concluded, among other things, that stalking presents a serious problem in the Cayman Islands and it requires legislative intervention. So, Mr. Speaker, pursuant to that report, a special advisory committee on gender violence was established. And in 2008, the then cabinet issued a directive that the issue of gender violence should be examined by a committee established by the Portfolio of Legal Affairs in consultation, Mr. Speaker, with the then Ministry of Health and Human Services. That examination, Mr. Speaker, was to fall within the parameters of the Law Reform Commission. Mr. Speaker, it was back then that I instructed the Law Reform Commission to conduct its research into the issue, and on the 5th of February 2015, the Law Reform Commission submitted its final report on stalking legislation. Mr. Speaker, the report contained a number of proposals aimed at addressing the problems relating to stalking by defining stalking behavior and identifying appropriate legal remedies to prevent or reduce harm brought about by such behavior. It was felt at times, sir, that the penal code, which criminalizes acts of harassment and watching and besetting, did not address stalking as an independent problem. It was also felt, Mr. Speaker, that the current legislation treats stalking behavior in a piecemeal way and deals with isolated incidents of criminal behavior rather than looking at it as a more continuous problem. Mr. Speaker, with respect to the civil law, the law of tort is relevant to stalking, given that stalking is a form of wrongdoing which often results in harm, loss, and sometimes expense. Mr. Speaker, such loss may include personal injury, psychological and emotional distress. It could also include or involve depression, and of course, Mr. Speaker, loss of income and a wide range of expenses from moving costs to counseling and sometimes the cost of therapy. So, Mr. Speaker, with these types of occurrences, legal remedies which affords the victim certain protections and allows the victim of stalking to recover monetary damages for losses would therefore be understandably appropriate. And hence, Mr. Speaker, the bill before this Honorable House. So, Mr. Speaker, Clause 1 of the bill, of course, speaks to the short title. Clause 2, Mr. Speaker, is the definition clause, and it defines, among other things, the terms including stalking, complainant, respondent, and of course sets out what is meant by protection order. Clause 3, Mr. Speaker, identifies the elements that would constitute stalking. In this regard, stalking requires a course of conduct directed towards a specific person on 2 or more occasions within a period of 12 months, and the conduct should cause a reasonable person, Mr. Speaker, to fear for that person's safety or the safety of someone connected to that person. Mr. Speaker, Clause 3 is expansive in its recognition of the types of conduct that would constitute stalking. These include A, watching, besetting, or loitering near that person, approaching or entering a place where that person resides, works, or visits. It also, Mr. Speaker, includes preventing or hindering access to or from that person's place of residence, place of business, the place of employment, place of learning, or any other location which that person visit. That person, now, Mr. Speaker, being the victim. It involves following or accosting that person. It involves entering or interfering with that person's property, engaging in verbal, written, electronic, or any other form of communication with the victim. It includes, Mr. Speaker, giving offensive, abusive, or threatening material to that person, or leaving it where it will be found by, or given to, or brought to the attention of the victim. It includes, Mr. Speaker, sending, delivering, or showing to that person letters, images, telegrams, packages, facsimiles, or electronic messages, or acting covertly in a way that would reasonably be expected to arouse apprehension or fear in the victim, Mr. Speaker, or just downright intimidating, harassing, or molesting that person. Mr. Speaker, Clause 4 provides for the procedure to be followed when seeking to apply for a protection order. It permits an application to be made against the respondent or any other person counseled or procured by the respondent to stalk the complainant. Mr. Speaker, Clause 5 provides that a person may apply to the court to be appointed as a representative for a person who has been or is being stalked. And Mr. Speaker, the person who may be represented in such circumstances include a child, a person over the age of 17 years who, Mr. Speaker, due to some physical incapacity or fear or injury or any other sufficient cause is unable or unwilling to apply to the court for protection order on his or her behalf. Mr. Speaker, Clause 6 stipulates that a person on whose behalf such an application to the court is made for protection order is not precluded himself or herself from being heard in the proceedings. Mr. Speaker, Clause 7 of the bill provides that the court shall, as soon as it is reasonably practicable, consider an application submitted to it for a protection order. This, Mr. Speaker, is in recognition of the irreparable harm that could potentially result from continued act of stalking. Clause 8, Mr. Speaker, permits a protection order to be made on an ex parte application if the court is satisfied that the delay that would be caused by proceeding by way of summons may result in a risk to the personal safety of the complainant or to the safety of a person connected to the complainant, Mr. Speaker. Mr. Speaker, Clause 9 of the bill is also very important. It provides that the protection order shall, for the purpose of protecting the complainant or any other person mentioned in the order, which amounts to stalking, and may prohibit the respondent from engaging or attempting to engage in a course of conduct which constitutes stalking. Mr. Speaker, it may also prevent a person from approaching or otherwise making any contact with the complainant or for committing any other acts specified in the protection order. Clause 10, Mr. Speaker, empowers the court to make the order for such a period as is necessary to protect the complainant. And of course, importantly, Mr. Speaker, Clause 11 provides for the issuance of a direction by the court to a police officer to investigate any allegation of stalking. Mr. Speaker, one could readily understand the basis of Clause 12, which provides for the issuance of directions, Mr. Speaker, to a service provider to assist in identifying a respondent where the complainant is being stalked by means of an ICT service or ICT network of the service provider. The investigator, Mr. Speaker, ought to be able to access that information. Mr. Speaker, Clause 14 provides that the court may, in the interest of any person and the public interest, make an order prohibiting the publication of any report or account of the whole or part of any proceedings relating to stalking. This provision, Mr. Speaker, seeks to acknowledge the sensitivities and the trauma associated with the conduct and how it may adversely impact a victim, Mr. Speaker, if it is published. Mr. Speaker, Clause 15 of the bill permits a police officer who has knowledge of the name or address of a person who is alleged to be stalking another person or has stalked another person to request that the other person, that second name person, or the person's representative to disclose the information to the court. Clause 16, Mr. Speaker, provides for defenses which a respondent may rely upon to justify their conduct, and these, Mr. Speaker, may include the respondent contending that the conduct was pursued for the purpose of preventing or detecting a crime, or that he acted under an enactment of a rule of law, or that he was doing so in order to comply with a condition or requirement imposed by a person acting under, a second person acting under or by virtue of some law. Or he might contend, or she might contend, Mr. Speaker, that the conduct was reasonable for the protection of the respondent or other person, or for the protection of the respondent's property. Mr. Speaker, Clause 17 provides that the standard applicable in any proceedings under this legislation, other than criminal proceedings, shall be decided on a balance of probability. Mr. Speaker, that's the level of proof. Mr. Speaker, Clause 19 permits a court to hear and determine an application for protection order in conjunction with one or more other applications for protection order in any case, Mr. Speaker, where the court is of the view that the applications are being made against the same person. And following that, Mr. Speaker, Clause 20 permits the court to dismiss any proceedings instituted under this law, under this legislation, if it is satisfied, the court is satisfied, that those proceedings are frivolous or vexatious, or, of course, it was an abuse of the court's process. Mr. Speaker, the legislation goes a little further than that, in that the clause makes it an offense for a person who knowingly or willfully make a false, or vexatious, or frivolous complaint against another person for an alleged contravention of any provision of this legislation. Mr. Speaker, this is understandable. There are instances, as you know, where there are busybodies who might make false or frivolous allegation against someone, accusing them of stalking. And this is a bit of safeguard being inserted in the legislation to deal with that eventuality. Of course, Mr. Speaker, Clause 21 provides for the award of cost by the court against any person if the court is satisfied that the person acted frivolously or vexatiously, or that the person abused the process of the court. And, Mr. Speaker, understandably, Clause 22 of the bill provides that a person who claimed to have been stalked by another person, or who has been the subject of a frivolous or vexatious claim, may institute civil proceedings in court, Mr. Speaker, to claim damages for any anxiety or distress caused by the stalking, or any financial loss resulting from those conduct, or, Mr. Speaker, any harm resulting from the stalking, or any other matter which the court believes justifies an award of damages. And of course, Mr. Speaker, Clause 23 simply deals with a right of appeal to the Court of Appeal from the Grand Court decision. Mr. Speaker, Clause 25 of the bill provides or enables Cabinet to make regulations for the effective implementation of this piece of legislation. So, Mr. Speaker, the government believes that the enactment of this legislation would address the inadequacies of the criminal law and the civil law as they relate to this issue of stalking, and would serve, Mr. Speaker, as a recognition by the government that comprehensive protection should be made available to people who fear that they will become victims of violent activity in the immediate future. And so, Mr. Speaker, the legislation would reinforce that actions which constitute stalking, which cause psychiatric and psychological harm, and may result in serious danger to persons being stalked, are to be dealt with. And as such, Mr. Speaker, the measures outlined in the bill are pointedly meant, Mr. Speaker, to be a response by government to such a conduct. Mr. Speaker, I hope I have outlined the main features of the bill, and I certainly would wish to commend it to members of this honorable House for its passage, Mr. Speaker, the Stalking Civil Jurisdiction Bill 2018. I thank you, sir.
Does the member from Georgetown Central? Are you giving way to someone else, or?
I was giving way to the acting opposition leader.
The member from Newlands?
Thank you, Mr. Speaker. Mr. Speaker, I rise to give a brief contribution on behalf of the opposition with regard to the bill now before the House. Clearly, Mr. Speaker, the opposition supports the introduction of this legislation and its timeliness. I think we would all agree, Mr. Speaker, that the prevalence of these sorts of offenses is increasing, and unlike years ago, we are seeing more and more examples of where stiffer penalties and legislation is needed. It's also a step forward, as the Honorable Attorney General said, in offering protection to those who are more vulnerable in our society, in particular women and children. I think, Mr. Speaker, in my first term in office, I recall actually getting a call from a lady who was having issues with the husband that she'd separated from, who was actually engaging in activities that could only be described as stalking with a very dark undertone. He was trying to locate her to cause harm to her. And this lady called me. She was frantic, fearing for her life, fearing for the life of her children. And while we do have support groups out there in our society that will assist, especially women and children, during these times, the lady went on to explain to me that she needed help immediately. And due to some delays that she was experiencing, I'm not quite sure why, if that is the norm in getting a restraining order and so forth, but she was unable to get one in a timely manner. And she was having difficulty getting her position put forward in the courts and getting the necessary protection she needed. Quite recently, Mr. Speaker, another young lady gave me an account of what was happening to her. This is a very young lady who was actually in university at UCCI. She was being stalked by an individual, threatened, tried to basically take money from her whenever he could, showing up at her home, uninvited. But it also became physical. And this young lady was embarrassed because she had been involved with this gentleman. I'll use the term loosely. But he, Mr. Speaker, had taken advantage of her and became quite obsessed and violent. In going to report it to the police, she discovered that she wasn't his only victim. He had what you would refer to as a rap sheet, as long as my arm and leg, all similar offenses. This legislation, Mr. Speaker, is very timely, as it provides the protection, I think, that, as I said, the more vulnerable members of our society need. And I'm also glad to see, Mr. Speaker, that the government has seen fit to offer protection as well from frivolous reporting and accusations being made. As we know, those do happen from time to time. Thankfully, they're not as prevalent as the other. But, Mr. Speaker, I do note that I have some points to make with regard to the actual bill. And I do see there's quite a bit of overlap with the bill that will follow. So I'll try to separate the issues. However, I just wondered, in looking at both pieces of legislation, why, if it couldn't have been all done within the penal code and then refer to the penal code through this. I don't know, but it was just an observation. Because I'm just thinking later on when it's come times to make amendments, both pieces of legislation have to be amended at the same time. But that is just an observation I made. But Mr. Speaker, looking at the bill itself, and I'm looking specifically at section 3(2), which says, for the purposes of subsection 1, a course of conduct in relation to a person includes, and then looking at section D, following or accosting that person. And that one just sort of jumped out at me because I could follow the other ones, but accosting in some situations could be considered a case of common assault. The penalty set out for common assault is 1 year. However, in the case of it being used in stalking or accosting, the criminal penalty would have been 4 years. It's just an observation that there may be some conflict there as well. Not trying to be soft on this sort of behavior. However, I'm just wondering if the government has actually done the research to see, looking at previous cases which would have been tried and ended, knowing the end result and knowing the facts of those cases, if they were then subjected to the test of this legislation, how many of those would actually result in a conviction for stalking versus assault or something else, common assault? Section 3(2)(I), which reads, acting covertly in a way that could reasonably be expected to arouse apprehension or fear in that person. I'm assuming this, when you think about this in literal sense, it's, someone acting covertly. It could be someone hiding in a bush waiting to accost someone or just, do something to an individual. However, I'm wondering if this also applies to the use of technology. I know the bill actually mentions ICT violations and so on later on, but the use of spyware to spy on someone through their computer, phone, whatever it may be, hidden cameras, things of that nature. I'm just wondering if maybe when the Attorney General replies, if he could confirm that that is the intention here by using the word covert. So, Speaker, in section 3, sorry. Let's see. Sorry, 3(2)(3). A course of conduct under subsection 2 may be the same course of conduct or different courses of conduct pursued on each occasion. Well, I think the Attorney General has now explained that it doesn't have to be the same offense all the time. It could be any one of these that falls under the definition. So I think he's explained that now. In section 16D. I have a bit of a concern with this one, Mr. Speaker, where it says, it is a defense for a respondent to show that, and it goes through the different scenarios, A, B, C, and D, the respondent's conduct was reasonable for the protection of the respondent or other person, or for the protection of the respondent's property, or the property of another, or E, the respondent had no reason to believe that there was any person within hearing or sight who was likely to be put in fear as a result of the respondent's conduct. Wouldn't it make more sense, Mr. Speaker, to submit that to a reasonableness test where you would say where a reasonable person would believe rather than the respondent himself? Because it's almost as if you're asking the accused person to offer up an excuse for why they committed the offense. And if that's within reason, then the court would not find them responsible. I would prefer to see in there maybe something along the lines of a reasonable person would have no reason to believe that there was any person within hearing or sight who was like to be put in fear as a result of the first mentioned person conduct or something along those lines. So you subject it to a more general test rather than something subjective based on the defendant's point of view. I think, Mr. Speaker, that would also be fair when considering that circumstances of each case are going to change over time. As new cases come up, the circumstances will change, so making it as general as possible in making that assessment, I think, would be useful. And Mr. Speaker, I do have other comments for the bill that will follow, which accompanies this one. But those were the main ones that jumped out at me from a civil point of view. I also do, maybe the Honorable Attorney General can address this when he responds as well. The fact that we have two different burdens of proof at play, one on the criminal side and one on the civil side. Clearly, on the criminal side, beyond reasonable doubt and balance of probabilities, two different ways of assessing criminal liability. One may be easier proven than the other. So, okay. Well, yeah, one civil, one criminal, sorry. But then two different sort of measuring sticks at use. So it just presents me with a bit of a quandary. Apart from that, Mr. Speaker, on this bill, I am glad to say that I think we will all be giving it our support. I'll have more to say when we get to the following bill. But I think I'd like to thank the Attorney General for pushing this forward. It is, again, timely, something that is needed, very much needed in our society now. It's sad to say, Mr. Speaker, because our country is changing on a daily basis, and whereas incidents like this were rare in the past, we're seeing now more and more that these sorts of incidents happen on a more than daily basis. And we have to do all that we can to offer protection, especially to our women and children in our society who are very often the victims of this sort of activity. So that said, I just want to thank the government for bringing this forward, and I look forward to supporting the bill.
Any other member wish to speak? I'd caught the eye of the member for Georgetown Central.
Thank you, Mr. Speaker. Mr. Speaker, I don't intend to give a long, drawn-out contribution, so I'll try to make it as quick as possible. First, thanking the Attorney General and his team for presenting a bill, like my colleague has said, that is very timely, but also to recognize some private sector stakeholders who have given much contribution to the success and push of this bill to reach the floor of this Honorable House. and we have two of those members from the Business and Professional Women's Club in the audience today who were instrumental in trying to get the government to bring this bill forward. Mr. Speaker, the acting opposition leader have said much about the bill, and I concur with everything he has said, but only to bring attention to one area of the bill that is of concern for me. And I don't want to repeat what the acting opposition leader has said, but I believe that in respect to those persons who make frivolous claims of a person committing the act of stalking, in this bill on 26, it suggests that a person who is, in the opinion of the court, knowingly or willfully makes false, vexatious, or frivolous complaints against another person for an alleged contravention of any provision of this law commits an offense and is liable to a summary conviction or a fine of $5,000 or imprisonment for a term of 1 year or both. 26, page 17. Now, Mr. Speaker, the reason I highlight that is, though I think this bill does highlight all the areas of concern for persons who are committing the crime of stalking, I think that we need to have a stronger deterrent of persons possibly maliciously using this type of legislation to undermine another person. And if we're going to have convictions of years of imprisonment for a person who's caught and being found guilty by the courts, I think it should be not exactly, but almost the same in respect to if you are caught trying to get somebody to be found guilty of that crime. Because if we think about it for a second, if somebody was to be successful in falsely accusing somebody of doing a crime of stalking and they were found guilty of the courts, how long they would serve in prison. So in some areas we have up to 4 years potential chance to be locked up for stalking, but if that person was later on found out afterwards that it was all a lie, the only thing that they would be penalized to is a mere $5,000 or imprisonment for a term of 1 year. And it depends on the courts. They could probably not even get the 1 year and just the $5,000. I think there needs to be a strong deterrent from persons who try to use this because, Mr. Speaker, though I know that this bill protects women particularly and the vulnerable and the elderly and the young, I also have to think about the flip side of the sad stories that I heard of, say, unhappy ex-girlfriend who wants to make the boyfriend or the ex-boyfriend get him in trouble because he left her or something like that. And in this, with a mere $5,000 for potentially sending a person away for 4 years of their life, I don't think is a strong enough deterrent. So I'm not going to dwell on it too much, but I would hope that they, and when it comes to committee stage, potentially considerations to increase that amount so it could be a stronger deterrent from persons trying to use this law in a malicious way, because we know that there's been many cases of that. And also to commend the government for bringing this bill. It's something that is important to both sides of this legislative assembly in respect to the protection of anybody who's stalked. And like my good colleague, the acting opposition leader, has said, it's sad that we're here, but it's good to know that we have a group of legislators here who would all agree that it's timely and will give it support. So that is my contribution. Thank you, Mr. Speaker.
Mr. Speaker.
Honorable Premier.
Mr. Speaker, I beg to move the suspension of Standing Order 10-2 in order that the business of the House may continue beyond the hour of interruption.
Question is that the House to suspend Standing Orders 10-2 in order to continue beyond 4:30. All in favor?
Aye.
Those against? The ayes have it. Member for East End.
Thank you, Mr. Speaker. Mr. Speaker, it appears to me like I should have started off this debate because my approach is going to be a little different from my colleagues on this side. Not altogether different, but certainly with some concerns that I have. Mr. Speaker, while I support legislative measures to deal with this growing problem that is becoming almost an epidemic in this country, I believe that this bill, the bill plus the amendment to the penal code does not cover some of the areas that needs to be covered. And I hope that my contribution will be received as criticism, but constructive criticism or proposals to look to see where and how we can reach that point. And if the Attorney General believes that what I'm about to say is already covered in the law, in the bill, then I would respectfully ask that he explain that in his response. Mr. Speaker, there are a number of areas in this bill that gives me reason to pause. Mr. Speaker, we all of us, at least those of us who have been here for many years, have had, may I say, numerous complaints from women in particular about areas of abuse, harassment, and the lack of police ability to intervene. Therein lies much of my concern. The Attorney General gave a story of someone from Canada who came here and their boyfriend followed them. Now, Mr. Speaker, I can relate many stories of Caymanian women who have had to even leave this country because of the same thing. I can relate stories of women living as common law, boyfriend, girlfriend, and the relationship break down, and when the young lady tried to leave, they were prevented from even recovering their possessions. from the residents. And when they call upon the police tell them that it's a civil matter and they can't do anything about it. And I believe that this does not go far enough. There are provisions made in the penal code, but the amendment to the penal code that is coming, and if you will permit me, I'll just mention that. But in this Stalking law, bill, the police can only act under this if the court so ordered. And yes, I understand the separation of civil and criminal, i.e. the penal code. But I still do not believe that it is adequately covered in the penal code, and we're going to allow the police to have a way out of that situation again. Now, Mr. Speaker, I have known of, and I know of, wonderful young ladies with at least one child, and they're seriously threatened, and the Attorney General went through all these scenarios, psychological and whatever, of what causes these things. But this love story causes a lot of it too. And young ladies who I have personally assisted to get out of this country, when they get illegal guns placed in their mouth, that is worse than stalking. That is intimidating. And it deserves to be addressed from a criminal perspective. Yes, Mrs. Speaker, I know I'm going to hear that there is a process, there's a criminal process whereby complaints can be made. And the only process available now for those ladies is that they can go and get their lawyer to get a restraining order through the courts. And that needs to be proven, what have you. This provides relief in that regard, but it still has to go through the court, and you need to get some representative, or you can go yourself, but you need to find some representative to represent you or to be in charge of you, such as a youth, someone under the age, and the likes. But Mr. Speaker, until that restraining order has been put in place, that restriction, the police have no authority. So that leaves the police in a position that they still cannot go in and assist anyone. I think it's Section 9. (9)(2). But 9 reads that a protection order shall, for the purpose of protecting the complainant or any other person mentioned in the order from conduct which amounts to stalking, prohibits the respondent from engaging or attempting to engage in a course of conduct which constitutes stalking. Enlist the help of other persons to engage in a course of conduct, approach which constitutes stalking, approach or otherwise make contact with the complainant, committing any other act as specified in the protection order, which would be a restraining order, so to speak, that is currently available to a complainant. Now, subsection 2 says the court may impose an additional condition on the respondent, which it deems reasonable and necessary to protect and provide for the safety of the complainant or a person known to the complainant. 3, the court may order a police officer to seize any weapon in possession or under the control of the respondent. So I am assuming that's a licensed firearm they're talking about, because you're not going to get the illegal one. You don't know that the person has an illegal one. So it is a licensed firearm that you are aware of, the state is aware of, and should be able to seize that. Yes, because something could happen with them using that weapon. B, accompany the complainant or a person known to the complainant to a specified place to assist with arrangements regarding the collection of personal property identified in the application for the protection order. And C, investigate the complaint of stalking with a view to instituting a criminal prosecution against the respondent. Now, Mr. Speaker, that's where the Attorney General and I are going apart. To some degree, there's going to be some space between us here, in that is the time under this that the police can enter, only when there is a protection order in place. And I understand the civil side, but the criminal side under the penal code will certainly give the police that authority. But once a stalking complaint has been made, we're still going to see the excuse that they can't do anything because it's civil. Somehow we need to correct that. Somewhere, somehow in this legislation, we need to do that. Mr. Speaker, I have known even of complainants calling 911 or one of the police stations. And once they have explained themselves, they are told there's nothing we can do. You're going to have to go and get a lawyer and go and get your possessions from the house and what have you and what not. We need police intervention in these matters, because too much of these things are happening, and they're going to end in disaster. They're going to end not well. Now, Mr. Speaker, relating that section, which is 9.3, to 16. If the respondent gets the court, the perpetrator gets the court as a respondent, 16 says that his defense can be that his conduct was pursued for the purpose of preventing or detecting a crime. Really? We going to give him the right to say that somebody was committing a crime? Tell him call the police, him or her to call the police. That's what we're doing with the complainant. We're telling them to make a complaint to the court. But he or she can get up there and defend themselves by saying, I believe that person was committing a crime, or I was trying to detect it for the police. The only entities or individuals that I am aware of for the enforcement of what I have been doing here for the last 18 years and you for the last 34 today, Mr. Speaker, is armed forces in this country. We, as ordinary citizens, have a line into those armed forces. Now we're making another one shortly, a border protection. But we're in this law saying that a man can say, no, I can understand a policeman saying that he was trying to detect or prevent a crime, but that responsibility does not lie with the citizen. If you see a crime being committed or believe that a crime is going to be committed, you call 911. We have promoted that since 99, 98, that we, somewhere in that area, 97 to 99. We put in the 911. Prior to that, we were calling the Georgetown Police Station or any other police station, Cameron Brack, wherever. It goes on to say, the respondent conduct was pursued under an enactment or a rule of law. We're leaving them to determine that now. The respondent conduct was pursued in order to comply with a condition or requirements imposed by a person acting under an enactment. The respondent's conduct was reasonable for the protection of the respondent or other persons, or for the protection of the respondent's property or the property of another. Now, I am told that I have the right to protect my property within reason, but my first line is to call the police. Mr. Speaker, I think it's a drug law. Tell me. I think it's a drug law where the burden of proof is on the defendant. You must prove you didn't have it and it wasn't yours. But we are here giving him reasons. We spelling it out for him too. I believe that needs to be removed and say the burden of proof is his to make, is the respondent's to make. And if it's reasonable, then the court, and I know, Mr. Speaker, the AG is going to get up and say, well, you got to prove either one of them. But let's not give him reasons to pick one. We know how these lawyers are. The same way the Attorney General's lawyers will have their say, the defense ones will have theirs too. I believe that it must be the responsibility of he who committed such acts to prove their innocence. Mr. Speaker, I know that the Penal Code Amendment, which is to come, will speak to these matters too. But Avery, so it's not only here. From the criminal perspective, it's the same thing. If you are having difficulties with someone, you know, speak of one of the things we have been practicing in this country ever since I came to knowledge, is if we don't engage in dialogue to resolve our issues, we love to go and destroy people paint on their cars. That's how we started it. That's how we started it. And that is the broken window syndrome. Now it has escalated to something else. We cannot afford to give people reasons to defend themselves. The burden of proof must be on the individual. That's my view, Mr. Speaker. That's my position. I liken it to allowing citizens to take the law into their own hands. When you tell him his defense can be that his behavior, his conduct, was pursued for the purposes of preventing or detecting a crime. Really? What are you going to do when you get there? Wow. That gives me reason to pause, and it should give all of us reason to pause. And the Attorney General may have some good explanation for it. suspect that he does, or he wouldn't have proposed it to this legislature. But little layman like me, lowly little layman, what I see is what I interpret. Mr. Speaker, there may be legal justification for putting it in there. I would like to hear them. Because I can't recall in many pieces of legislation such excuses being provided for a perpetrator. Mr. Speaker, one of the other areas that I want to briefly comment on is that of this lengthy provision in here on ICT providers. I'm not quick to commend, and we all know that, and the Attorney General has said that I don't do much of that with him. But in this case, I wonder why we had to put it in here. Mind you, I'm glad to put it in. Why we had to put it in here. Here we are again, making excuses for those who have the regulatory responsibility to ensure these things happen. Mr. Speaker, the courts, there's no need for us to continue to mirror legislation in other legislation. Off-reg legislation, what was it? ICTA, is very clear. The police can get this information. I became minister shortly after the ICTA was put in place. A few years ago, we changed the fines to increase them up to $500,000 on any, I think it was last year, maybe 2 years ago. For these providers when they do not comply. Here we are, the Attorney General, in his infinite wisdom, trying to make something happen to ensure that this information gets to the court, now has to put it in the hands of the court to be able to enforce that and put fines on them. What's it, $2,000? I think it's something like $2,000 if they don't comply. Mr. Speaker, it's someplace in here. Mr. Speaker, I believe the worst thing ever happened to this country is this ICT deregulation. Because it's worse now than it has ever been. They have a responsibility. When the court orders that they want information, that they do it. And our FREG has that penal code of $500,000 in fines, up to. Yet, we have to try to give the courts some relief here by putting penalties in here. We need to stop making excuses for those who are responsible with the regulatory authority in this country, who do nothing. We get it on our phones all the time. I paid plenty of money for my phone. So did we all. But every minute they send me messages from Flow saying they having this function or they having this draw or they having this thing. I must have the right to request that. There is no such thing as opt-out. Not on my personal property. The data protection prevents them from harassing me. That's the next motion. Every minute. That's like junk mail in your post office box when you're paying for it. I do not want it. Ask me if I want it, then I can say yes. Mr. Speaker, this will be the second time I commend the Attorney General for trying to do something with it, because it ain't being done the other side. It is not being done through ICTA. And it's not being done through off-right. We can't be afraid to address these matters. I have been coming down here for 18 years. And all we do is make laws that we believe is going to enhance our people's lives, and those we put in charge of the ensuring that the laws are enforced and the laws are implemented, do nothing, and we make excuse and come back and make another law so that we can counter them. I didn't come here like them old big rigs with big tires on it to spin my tires in the mud. That's not my purpose here. And the Attorney General, poor him, he knows that if the court doesn't have the ability to enforce it, but I should say to him that if the court doesn't have the ability to enforce it, they're not going to do it. He knows that. I know that too. But all he's given the court is chicken feed. Now I'm growing some kind of corn. $2,000. Put the court 500 too. 500,000 too. Since they won't do it up there, I'll bet you those grand court judges will do it. And some court judges will do it. Somehow this needs to be corrected. We're spinning our wheels in mud. We're burning rubber. It looks like we're getting ready to race, but we never come off the start line. Everybody sits down and says, oh yeah, you're doing a good job, don't worry. I'll put it in another law so someone else take responsibility for it. I just don't understand how we can engage people. They do nothing, and at retirement we have party for them. We should have them on a leaving party. Go home now. We never get to your age. I have to take full responsibility for it as a legislator when one of my constituents is harassed and they come to me and the court, in the absence of this, the court or the police request it and it's not provided. And nobody does anything about it. Mr. Speaker, I know the AG just cross-talked me, and what he's saying is that the court should have the ability to do it, and I totally agree with him. The emphasis is that the reason the court is requiring that ability is because the fines that we allow them to apply for non-compliance of instructions given by ICTA is not being applied. And the other part of that is the $4,000 that we are proposing here should be much higher. They must know that they must provide this information with haste. Let's increase that to 50,000 then. That'll only be 10% of what they can do up at offering. Let's increase it to 50,000. I should, Mr. Speaker, I will not be long. Hear that. Mr. Speaker, this is something I just need to bring to the Attorney General's attention. I think it's 12.7. Are you following me? 12.7C. I'm sure you will. You don't want me to say what that error is there. Twelve 7C at the end of it. Since this is gender neutral. And I'm sure the minister from Cameron would love that one. But I guess that can be done in committee stage. Mr. Speaker, I know a lot of what I said was more from the perspective of trying to get something for relief for the many young women that I've encountered who, and all of us, I know it, who are having difficulties with, especially if they're single parents. And yes, I know this can go the other way too, because we have some rough women around here. Many of us can speak, and many of us can go give testimony to that. We have some rough people of the opposite sex. As much as we like to say that women are the weaker sex, I would not advise anybody to use that in a general term. Because I've seen some tough hombre, they call it, would be. I don't know, but I've seen some tough ones who who has not shied from any man.
But if you give them bun, what do you expect?
But, Mr. Speaker, and this is this is very fresh in my memory. That's why I believe I needed to explain to the Attorney General in this Honorable House what is happening. The key is police hands are tied, or they're telling them their hands are tied. And a police should be allowed to protect. If we want to talk about this is for the protection of the most vulnerable, the police should be allowed, without question, to protect the most vulnerable. And it is my submission, Mr. Speaker, that the most vulnerable in this country that falls within the ambit of this new piece of legislation happens to be women, but importantly too, right on the heels of that, single mothers. It is of paramount importance that we put legislation in place that when they pick up that phone, it is the same thing, the response is no different than any other crime that is being committed. When we reach the penal code, I will speak on that because I do not believe that it is good enough. I'm not saying it's not good. I believe it does not reach far enough. It does not go far enough. And the Attorney General needs to explain that by law, but certainly I know if I'm not getting it, I don't know if all the policemen are going to get it. So someone needs to explain this. This thing, I've had to deal with too many. I've had to be preacher and mediator and Mr. Speaker, I'm not saying me alone. We all have had to do that, including the Premier and the Speaker. Try to resolve these issues between the opposite sex in relationships to prevent them from getting killed because the police can't deal with it. We have had to do it. And this time we put some, what we say, braces around it and corral somebody and put rope on them and take them down to Northport. You shouldn't be abusing people in that manner. Mr. Speaker, I shall await the response of the Right Honourable Attorney General. Thank you, Mr. Speaker.
Wish to speak? The member from Prospect.
Thank you, Mr. Speaker, for allowing me to make my contributions in support of this Stalking Civil Jurisdiction Bill 2018. In truth, I had not planned to speak to this motion, but I find myself led by the Spirit, and I am trying to listen to that ever-quiet voice, so that is the reason why I've decided to rise. Let me begin by saying good day to the constituents of Prospect, whom I have the pleasure to represent, as well as the wider Cayman Islands, either tuned in live to our proceedings or certainly in the replay this evening. Mr. Speaker, with your permission, before I make my substantive remarks in support of this Stalking Civil Jurisdiction Bill 2018, I wonder if you will allow me to briefly extend my deep personal condolences to the family of the late Mr. Danny Hugh, who himself was a constituent of Prospect. I had many conversations with Mr. Hugh, both during the election campaign and many times after being elected, and I say with all honesty and sincerity that he and those conversations will be sadly missed. I would like to extend heartfelt condolences first to my colleague, the Honourable Minister of Commerce, Planning and Infrastructure, and secondly, of course, to his immediate family, some of whom still reside in Prospect during this very difficult time. To the bill, Mr. Speaker, I also want to thank my unity government and the Attorney General for agreeing to further strengthen legislation in the Cayman Islands that will seek to further protect women and children in these islands. This is important to me, Mr. Speaker, because both the protection of women and children formed part of a significant pledge that I made to the constituents of Prospect in my manifesto, and I'm happy to see that this legislation is now being brought, which I think is very timely. We will recall in September, whilst we were on the sister islands, introducing legislation to protect our children against child predators by the introduction of grooming legislation, and likewise we are here today to seek support for the introduction of legislation to protect women against stalking. Mr. Speaker, notwithstanding the definitions already offered up by the Honourable Attorney General, stalking has been defined as a repetitive pattern of unwarranted, harassing, or threatening behavior, one person against another. And one of the reasons behind passing legislation or introducing legislation to protect against stalking is to help prevent future violence. Well, whilst it was certainly stated by the Attorney General in his contribution that it has been identified that stalking has become a serious matter for concern here in the Cayman Islands, I think it is important, therefore, that we all support what is the first step in establishing the legal framework to address the civil issues related to stalking. Again, we will address the criminal issues relating to the same in the subsequent Penal Code Amendment number 2 bill, which will come thereafter. And whilst, Mr. Speaker, I do not have any hard statistics before me this afternoon in the context of the Cayman Islands, according to the National Violence Against Women survey published by the University of Missouri, 8% of women and 2% of men have reported being stalked at some point in their lives. That equates to 1 out of every 12 women and 1 out of every 45 men have been affected by stalking. And as such, legislation to protect citizens against stalking exists in all 50 states of the United States and has been in existence in the United Kingdom since 1997 under the Protection from Harassment Act 1997. I think that this legislation is very timely, and I thank again the members and colleagues of this unity government for embracing the need to introduce this legislation, which I hope, following comments that we have already received from members making their contribution to this bill, that at the end of the day, we will see legislation introduced to, again, further strengthen and protect women of these beloved Cayman Islands. I, for one, Mr. Speaker, will be voting yes in support of this bill. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? The Honourable Minister of Financial Services.
Yes, Mr. Speaker, just to be very brief, as I know the AG has ably set out the genesis of the bill, the action taken by not just the government but also the civic organisations, in particular the work of the Young Business and Professional Women's Club, which I would like to certainly put on record in echoing the thanks to those women, young women, who saw the need to assist in providing the empirical research that they conducted to help inform what is now the Stalking Civil Jurisdiction Bill 2018 and the subsequent amendments to the Penal Code to be discussed in a later presentation. But also, Mr. Speaker, as I'm sure that the AG will deal with the explaining some of the nuances and I guess the differences with respect to civil jurisdiction versus criminal procedure and some of the questions that may have emanated as a result. So I will not deal with those, but just to say, Mr. Speaker, and I know we've heard it a number of times, but to emphasize, as you have heard me say on a number of occasions in this House, how important it is to bring gender-neutral legislation and how important it is for us to modernize our legislative framework to recognize the issues that affect both men and women in our community. And certainly, as the AG said, the statistics will probably bear out and show that in this instance, women are predominantly the victims, or I'd like to say and see it as survivors of these acts, and men are often the perpetrators. But, Mr. Speaker, the fact that this bill does reflect the terminology of complainant and respondent should not be overlooked, because there are, Mr. Speaker, and I guess I'm speaking on behalf of the men in the chamber as well as the men in the community who experience or have experienced these situations. But certainly, I'd like to thank the members of the opposition that spoke, that actually recognized and recognizes the importance that the government places on addressing these often heavily weighted gender issues, in particular, as I said, affecting women and children in the community. But this legislation certainly isn't limited to women and children and those who may be disabled. And so it's important to ensure that the men in the community who may be experiencing this feel that they do now have a voice. This legislation is within the civil jurisdiction, and so again, I leave that to the AG to deal with those questions that emanated about the various burdens of proof, etc. But this, I see, Mr. Speaker, is a piece of legislation that empowers the community. It empowers those persons, both men and women, and other categories of individuals who may be experiencing or who have experienced, and God forbid, who will experience in the future, situations contained in this bill, and it gives them the ability to take matters into their own hands in addition to filing the criminal complaints, and for the judicial system in that, or the criminal system to take action as a result of some of the changes we'll discuss in a minute. But also it gives the ability for the community to, as I said, feel empowered, that they don't have to just rely on waiting for the police to act in these instances. And so the complementary suite of legislation from both the civil side and the criminal side hopefully will signal to the community that as a country and as a government, we take these concerns of stalking and the negative ramifications that come as a result very seriously, and we're trying to address the concerns in a way that benefits the women in our community, the men in our community, and in fact, our entire community. So with that, I would like to also say that I will be lending my support to this bill, obviously, as a member of the government bringing it forward. Thank you.
Does any other member wish to speak? Does any other member wish to speak? If not, I'll call on the Honorable Mover for his right of reply. Honorable AG.
Thank you, Mr. Speaker. Mr. Speaker, I understandably wish to thank honorable members who have spoken on the bill and, as usual, have made very insightful contributions to the debate thus far. Mr. Speaker, I thought I start with some observations made by the Honorable Acting Leader of the Opposition. And I would like to join with him in again saying that the initiative is very timely. Very, very timely. And the government, as I mentioned earlier, sees the need to act and has done so with the usual alacrity. Well, Mr. Speaker, he mentioned a couple of provisions in the bill, and he asked, for example, why not one piece of legislation? Why have a civil regime and a criminal regime? And so, Mr. Speaker, the answer to that is relatively simple. The government is adopting a belt and braces approach to the scourge, if you will, of stalking. And as the honorable member from East End mentioned, there are instances when the police have been asked to intervene, and they, for one reason or the other, take the view that it is a civil matter, and unless they see some sort of an imminent breach of the peace and are imminent kind of harm or injury to the complainant, they would advise them to go and seek a restraining order, which is a civil matter. Mr. Speaker, what we are attempting to do here is to create a sort of a two-pronged approach, if you will, and for the benefit of the Honorable Leader of the Opposition, Acting Leader of the Opposition. Well, he would know this as well, though. The purpose of the civil law is to provide compensation to someone who suffered injuries by way of the conduct of another person, Mr. Speaker. So the provision in this bill that is being debated, which is a civil aspect of it, is if all of these conducts that are mentioned here, if at the end of the day the court finds that these conduct were carried out by the respondent, and that as a result of that, the person who was stalked suffered mental anguish or anxiety or some kind of a mental breakdown or illness. In our view, in the government's view, it would not be enough merely for the police to arrest and charge and the court convict that person and to go to prison. The complainant doesn't really benefit from that personally, although it is the state taking action, understandably, to deal with it. But the plaintiff or the victim would have suffered personal injuries. And the question is, how do you compensate that person? And so the way to do that is to provide civil remedy, where the person can go to court and get damages from the court, monetary award, to address those pain and suffering, anxiety, and all sorts of things. In addition to that, as a result of it, the person might rack up significant amount of expenses, medical expenses, to treat the anxiety and all sorts of things. And the court will be able to make an award, damages to cover all of those incidences and so on. But Mr. Speaker, parallel to that is that where the police is satisfied that an offense has been committed and warrant their intervention, you can have parallel proceedings taking place, things being done simultaneously. So you can have a civil matter before the court issue production order, person file his writ or file a writ and pursuing a civil proceedings, and the police treating with the matter as a criminal offense as well. And the person is arrested, charged, and potentially convicted for the stalking. And so that, Mr. Speaker, is a higher standard of proof. If someone is going to be convicted for a criminal offense, the burden of proof, the burden and standard of proof are different. So the burden would be on the state. The standard is proof beyond reasonable doubt that he was stalking that person. In a civil setting, the complainant or the victim only really need to prove on a balance of probabilities that he or she was being stalked. So it's a different level of standard of proof. And so, Mr. Speaker, it is important that these two parallel streams, if you will, are available to the complainant. One might very well choose not to make a criminal complaint and simply pursue the matter civilly, vice versa. The person might just decide not to pursue a civil complaint, but file a report with the police, and might very well take the view that an arrest and charge might be an appropriate deterrent for the person who's doing the stalking. Yeah, but we never have a bespoke cause of action called stalking. No, but I mean, so this is what this is providing a bespoke cause of action. It's called stalking. Mr. Speaker, just to round off on that a little bit, you would have heard the member from Prospect mention effectively that we are not reinventing the wheel here, or we're not breaking new ground, Mr. Speaker. The truth is that all over the world, common law world as well as civil, we have legislation in place dealing with stalking. Mr. Speaker, I mentioned about the genesis of this initiative going back in 2005. And the Law Reform Commission, Mr. Speaker, would have looked at various jurisdictions and compiled their report. Final report was compiled on 5th February 2015. In that, Mr. Speaker, exercise, they would have looked at other jurisdictions to see what has been done there. And the report, Mr. Speaker, confirms that in common law world, common law jurisdiction, including Australia, Canada, UK, New Zealand, you have such legislation, Mr. Speaker. You have legislation in Bermuda, and New South Wales. You have it in other places. You have it in the United States, Mr. Speaker. The United States have enacted anti-harassment or anti-stalking legislation in all states in the United States. And so, Speaker, we're not in any way breaking new ground here. If anything, I think we are probably playing a little bit of catching up in this area. So this also answers another question, Mr. Speaker, of the Honourable Member, Leader of the Opposition. I think he wanted to inquire how wide the consultation was. Mr. Speaker, the bill was published, the report was published as a public consultation, for public consultation. In addition, Mr. Speaker, there were focused engagements. It was sent to the judiciary, the Ministry of Community Affairs, Gender and Housing, the Law Society, the Bar Association, Kimberley Society of Professional Accountants, Society of Trust and Estate Practitioners, Chamber of Commerce, the Bankers Association, the Compliance Association, Human Rights Commission. All of these people were consulted, Mr. Speaker, in addition to the general public and the Professional Women's, Business and Women's Club. Mr. Speaker, the member also inquired why you have a reasonable man's test. Why is it that it is a respondent's reasonable belief that matters as opposed to an objective reasonable man's test? Mr. Speaker, the way the clause is worded, clause 16, I think it is. Yeah, clause 16. It says, it is a defense, Mr. Speaker, to show that the respondent's conduct was pursued for the purpose of preventing or detecting a crime. The respondent's conduct was reasonable for the protection of the respondents or another person, or for the protection of the respondent's property or property of another person. Mr. Speaker, this is not different from what obtains today. It is always a defense in these kind of circumstances for an accused person to say, I honestly believe my life was in danger, and that's why I shot someone or hit someone. It is a person's honest belief. That is a defense. Yeah. It has always been the case. One second. So, Mr. Speaker, in our penal code, for example, it is written there that it is a defense for someone to say, I was acting in self-defense when I killed someone. It is a defense in certain sexual offenses case for a defendant to say he believed that a victim was 16 or over 16, and so this is nothing new. What is important is that if the person raised that as an honest belief, he reasonably, its state of mind is of such that I think what I was doing is correct. It is still in this case, it is still the respondent, the plaintiff, the victim, who is alleging that he or she was stalked. The burden of proof is still on that person. Whoever asserts must prove. And so this person really just needs to flag this as a potential defense. But the burden of proof still remains on the victim who's alleging that he or she was stalked. Doesn't shift. It's the same thing with the criminal. With criminal under the penal code, we'll want to get to that, Mr. Speaker. These defenses are also available there. And it is at the Crown to prove, beyond reasonable doubt when they get to that the person who is alleged to have been doing the stalking was acting as such, not the other way around. And so, sorry, you said so. The respondent. So that that is where the conduct or whatever it is would cause alarm or by a reasonable person. I'm thinking of a parallel such as maybe an offense they call a fray, or where you create this kind of annoyance and fight and all of that, and you didn't have any reason to believe that there's anybody next door or something. I'm not so sure that's the best example. But the question is whether when you did all of this, you thought it was in some confine of some privacy and nobody would have been alerted or alarmed and thereby distressed by whatever was being done. And so, of course, you might be incorrect in your belief. And that is important because even though you might believe otherwise, if the facts establish that persons were alarmed or distressed by the conduct, it doesn't matter what your belief was. It might only go to mitigating the sentence or the penalty, but it doesn't absolve you from the offense. Mr. Speaker, I think the honorable member also wanted to know if the conduct has been done covertly, what it covers. I just confirm, Mr. Speaker, that the contemplation is that it would cover the full range, spying and a sort of a covert sort of behavior, including voyeurism, and the part of the defendant. So any sort of conduct like those that would put the person in fear or cause the person to be apprehensive. would constitute covert conduct for the purpose of the provision. Mr. Speaker, the member from Central Georgetown expressed some concerns about the level of penalty in respect of persons who are accused of and may be convicted for filing a frivolous and vexatious report. I've looked at the penalty again, Mr. Speaker, and it says a person who, in the opinion of the court, knowingly or willfully makes a false, vexatious or frivolous complaint against another person for an alleged contravention of any provision of this law, commits an offense and is liable on summary conviction to a fine of $5,000 or to imprisonment for a term of 1 year or both. Mr. Speaker, I understand, I hear the concern of the honorable member, but I would wish to assure him that a potential penalty of $5,000 or 12-month imprisonment is not a lenient sentence by any stretch at all. It is true that it is unlikely that the court is going to sentence a person to 5 years immediately, and especially on a first offense. But even a 3-year sentence in these kind of circumstances, in my view, and I'm sure others are of that view, would be a deterrent, quite a bit of a deterrent in these circumstances. So what I can tell the honorable member, we, subject to the government saying otherwise, we think at the moment the $5,000 on the 1 year limit is a good start. And if it is that there are reasons to believe that the penalty ought to be increased, if we start having instances where, God forbid, we have a number of cases start coming before the court and we have repeat offenders and so, then clearly the government would seriously take a look at making the penalty even more dissuasive, Mr. Speaker. But I think for now, what we have here is adequate to meet the justice of the case. Mr. Speaker, the member from Eastern, the honorable member from Eastern, I think may have misunderstood what we're trying to accomplish here in terms of, I mentioned earlier on, the parallel streams, Mr. Speaker. The civil as well as the companion criminal provision of the law. He's of the view that because the civil bill does not provide or create a criminal offense for stalking, then there's this possibility that when the victim makes an allegation of stalking, the police is likely to say that it is a civil matter and to use his word, refuses to touch it. I mean, refuses to touch it. And probably direct the person to go and get a restraining order. Mr. Speaker, what is before this House is the exact opposite. What we are proposing to do here is to address the current lacuna, whereby when a report is made to the police now, as the law stands, the police is likely to say, you need to go to the courthouse and try to get a restraining order because it is a civil matter. You're going to get an injunction. This legislative framework that we're putting in place, the combined effect of it is that in addition to the person being able to go and get a restraining order and a protection order, or whatever order from the civil court, the person can simultaneously lodge a complaint, criminal complaint against the stalker. The police, as is provided for in the bill, can, without a warrant, Mr. Speaker, clause, and I beg your indulgence to kind of get ahead of myself here with the Penal Code Amendment Bill, but it's a companion piece of legislation, but I just want to contextualize it to answer his question. Under the Penal Code Bill, if this becomes law, the police may, without a warrant, Mr. Speaker, arrest a person for stalking. So there's a criminal provision in the law, Mr. Speaker. Police officer may arrest without a warrant anyone who reasonably suspects of committing an offense under this section. And the section is the section that sets out all the courses of conduct that constitute stalking. And so, Mr. Speaker, the police would not have any excuse to say to the victim that this is a civil matter and you need to go and get a restraining order. The police would be properly seized with the matter, would be properly enabled to arrest without a warrant where they think on reasonable suspicion that the conduct complained of by the victim amounts to stalking, Mr. Speaker. So it is a very holistic approach, if you will, to the problem of stalking. I know you will. Yeah. Mr. Sorry, Mr. Speaker, yes, I did mention before that what we have here was a two-pronged approach. He did mention, Mr. Speaker, about the parallel stream as well. What we have here, Mr. Speaker, is a two-pronged approach where you can have parallel proceedings, civil proceedings, where you can get a protection order and you pursue a civil action, and at the end of the day could receive damages for pain and suffering, distress, anxiety, etc. And the police, in the meanwhile, could also pursue a criminal investigation with a view to the person being arrested and charged, eventually prosecuted and convicted, for that. Mr. Speaker, finally, on the bill, the member spoke about the ability of the police to access ICT information. I am not sure of the reason for his complaint, Mr. Speaker. It is true that there are provisions elsewhere under the ICTA law, section 75, I think, or 76, and regulations for police to receive certain information from the ICTA provider. What we're trying to do here, Mr. Speaker, under these pieces of legislation, we're trying to create, as I mentioned before, a sort of a bespoke regime, framework, where the police, in one fell swoop, would have all the tools available to them, rather than having to cross-reference several pieces of legislation to find out what to do. It is all in one law. And they would be able to act with the necessary alacrity, if you will, and certainty in terms of how the provision for the ICTA, accessing ICTA information, is related to an allegation of stalking. They don't need to go to the DPP's office to ask, well, there's an allegation of stalking, am I able to use another piece of legislation to access the information to prove that? It is all a one-stop shop here, and so, Mr. Speaker, it provides for a sort of a harmonized approach, if you will, for want of a better word, in pursuing these kind of investigation. And there's really nothing wrong with that. I think it's a commendable approach in this way, Mr. Speaker. So I thank the honorable members for their contribution, and I would certainly understandably commend the bill to this House for its passage. Thank you.
The question is that a bill shortly entitled the Stalking Civil Jurisdiction Bill 2018 be given a second reading. All those in favor, please say aye.
Aye.
Aye. Those against, no. The ayes have it. The Stalking Civil Jurisdiction Bill 2018 has been given a second reading. $6:30.
The Penal Code Amendment Number 2, Bill 2018.
The Honorable the Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill, the long title of which is a bill for a law to amend the Penal Code 2018 revision to introduce the offense of stalking and for incidental and connected purposes.
The bill has been duly moved. Honorable AG.
Thank you, Mr. Speaker. Sorry. Mr. Speaker, you will recall, sir, that I alluded to this bill in my earlier presentation on the Stalking Civil Jurisdiction Bill. And the purpose of this particular bill, Mr. Speaker, is to criminalize any type of conduct which can properly be construed as stalking. And in this regard, Mr. Speaker, the bill is a companion measure to the civil aspect as it seeks to recognize the serious nature of the conduct by attaching a criminal penalty, or attaching criminal penalties for that matter, where it is proven that the person has conducted himself or herself in a manner that amounts to stalking. Mr. Speaker, having provided the background in my earlier presentation on this type of legislation, I would seek the leave of the House to merely summarize the provision in this short bill. Mr. Speaker, Clause 2 of the bill provides for the repeal of Section 155 of the Penal Code, which deals with the offense of watching and besetting, and it seeks to replace it, Mr. Speaker, with provisions which sets out the elements to be satisfied where the offense of stalking is alleged, Mr. Speaker, the types of acts that form the offense, and the defenses available when such an allegation is made against someone, Mr. Speaker. Mr. Speaker, the provision is necessary, provision is necessary as it is felt, sir, that the offense of watching and besetting in the penal code, that's currently in the penal code, do not adequately address all the factors that, when taken as a whole, would properly comprise the constituent elements of stalking. Stalking is much wider than the current language of besetting, watching and besetting in the penal code. Neither, Mr. Speaker, does the provision reflect the many forms that would possibly constitute the conduct of stalking. As such, Mr. Speaker, the elements of stalking and the types of conduct that may amount to stalking in this legislation are the same, Mr. Speaker, as those alluded to in the earlier bill, the Stalking Civil Jurisdiction Bill. And so, Mr. Speaker, what this bill now seeks to do is to broaden the range of conduct that will attract the criminal sanctions as it relates to stalking, Mr. Speaker. And you will therefore find, Mr. Speaker, that under this legislation, a person who stalks another commits an offense and is liable on conviction to a fine or to imprisonment for a term of 4 years or both, and on summary conviction, $5,000 or imprisonment for a term of 1 year. Mr. Speaker, the legislation seeks to empower a police officer to arrest, Mr. Speaker, without warrant, anyone he reasonably suspects of committing an offense of stalking. I alluded to that earlier on, Mr. Speaker. So the police do have the ability, if this becomes law, to arrest someone without a warrant if he suspects that the person is committing stalking. It doesn't need a court order for that, by the way, Mr. Speaker. The police officer, Mr. Speaker, may also, without a warrant, enter premises for the purpose of giving assistance to anyone present on the premises if the police officer has reasonable cause to suspect that a person is committing the offense of stalking, or the police officer has reasonable cause to suspect, Mr. Speaker, that a protection order under the Stalking Civil Jurisdiction law is being contravened. So, Mr. Speaker, you see this sort of correlation between them. If the victim is the subject of a protection order and that person makes an allegation to the police, and the police is of the view that the order protecting that person is being violated, is being contravened, the police has the power to make an arrest. Mr. Speaker, under the bill, of course, the defenses are set out there, and they are the same as in the earlier bill that I mentioned. And just to clarify again, these are defenses that are available to the person to raise as part of his defense. It doesn't necessarily follow that the court will agree or find or accept that these defenses are made out. But certainly these are understandable defenses that are available to someone. This is nothing new, Mr. Speaker. Just about every penal piece of legislation we have creates a set of offenses, defenses rather, that a person can rely on. And it is for the Crown to disprove in those circumstances. The burden of proof is on the prosecution. It's no different here. Mr. Speaker, the introduction of these defenses are in recognition of the fact that there are some instances in which the conduct may be necessary, or there may have been an awareness that the actions complained of constitutes stalking. And, Mr. Speaker, finally, as I mentioned, it's a short bill, so we're left with Clause 3, which deals with the transitional provision of, of this bill, Mr. Speaker. And so, given what has been said before in respect of the civil aspect of it, Mr. Speaker, I'm...
Mr. Speaker.
Sorry.
Member from Bordentown West, are you rising on a point of order?
Yes, Mr. Speaker. Just before the just a point of elucidation, Mr. Speaker. Before the
No,
attorney. Yeah, that's one of the acts. One before he sits. Oh. Okay. He didn't say it was a point of order. He said I misspoke.
If the AG cares to entertain it.
Thank you, Mr. Honorable AG. Just on section 6A, should that read subsection 3 or subsection 2? I just want to make sure before we get into the debate. Thanks.
Honorable AG.
Thank you, Mr. Speaker. Sorry, yeah. So, Mr. Speaker, I commend the bill, this companion bill, to members of this honorable House, and I'll be happy to answer any queries that might arise during the debate. Thank you.
Member from East End.
Mr. Speaker, thank you. Mr. Speaker, very short. The Attorney General, in his response to the Stalking bill, said that I had questioned whether or not police would consider this amendment to the penal code sufficient for them to get the job done. I assist with going in to assist others, the most vulnerable, in particular, young ladies. Mr. Speaker, I told him I would point out to him the intent of this amendment to the penal code is, one, to repeal section 155 of the penal code and replace it with the marginal note stalking, right? Mr. Speaker, this is a person stalks another person if the first mentioned person intentionally engages in the course of conduct specified under subsection 2, which, and then the different things is directed towards the second mentioned person, and then down to subsection 2. For the purpose of subsection 1, a course of conduct in relation to a person includes watching, besetting, or loitering near that person. Now let us look at what it currently exists. 55. 155 says a person who watches and besets. Same words. Any person, any premises, or approaches to any premises with a view to prevent any person from doing an act which such person has a legal right to do thereat, or be the house or the place, what have you, commits an offense is liable to imprisonment for 6 months. So my argument has always been that the police had jurisdiction, but they turn it over into civil matters. Now all we're doing is repealing that and replacing it with a little more, but it's the same intent. They had the jurisdiction before and they did nothing. And my argument was, and will remain, that these people are not going to do anything. They're going to turn people to the stalking law. That's what they're going to do, because, Mr. Speaker, the provisions were there. And the police continue to send our young ladies to go get a lawyer to make an application for restraining order. That's what they're doing. So, to my good friend, the Attorney General, I say to him, this is the mud now that I was talking about. We move from one area to the next to try to correct what they haven't been doing, and the provisions are there. Up to 6, now you may want to say that some of these things does not warrant 6 months imprisonment, and there should be a fine attached to it, and or. But provisions are there, that's why I said that. And they have done nothing. They continue. They can use all those in there about nuances and offenses against health. But they did nothing. They don't want the paperwork. And this is not, I repeat, not going to change it. There needs to be a paradigm shift in the police department. Someone needs to instruct them and sit them down in order that we can protect our people. Doesn't make sense for me to come down here and make laws and they refer to another one, which is a civil matter, so they don't have to do paperwork. Think that's why we're here? Changing the penal code? Provisions are there. All we're changing it and putting a few more words in. And then, and Mr. Speaker, I'm a little bit anxious about it. Fired? Fired up? No, I'm a little bit anxious about it because I've had so much experiences with it. And then you call the ops in the police and they tell you, well, that's a civil matter. Then I got $4 money out of my pocket to go get a lawyer, $150 for these young ladies go get a restraining order. 150 or no, sometime on that. But when it could have been done through the police department and a criminal charge apply. And this is what's going to happen with this. I promise you, mark my words, and them old people you say, this is going to happen again. Let's not get excited about putting a stalking law in place when it's for naught, when the police ain't going to do anything about it. This is just like the occasion my father told me that he was in New York with a gentleman and the taxi driver said it's $20 as $2 for the fare, and his friend gave him the $20 and walked off, and my father said, he said, hey, you got to wait on the change. He said, don't embarrass us here, Lester. You know zero don't mean anything where we come from. That's what it means. Zero. Nothing. Mr. Speaker, I also think that my good friend from Buddentown West got up on a point of elucidation, clarification, and on the 12th, I believe it's 3. Is it 3? 1-6, I believe. 2. It would have been 2-6. Yeah, 2-6A. And I noticed that and had it on the line as well. Because if you do subsection 3 just talks about a person who stalks another person commits an offense and is liable. So that is correct then? Okay. All right. Now, Mr. Speaker, the other section that I want to briefly touch on is 3, subsection 3, which we just spoke of. And it says, a person who stalks another person commits an offense and is liable on conviction, on indictment, to a fine or to imprisonment for a term of 4 years or both. B, on summary conviction, to a fine of $5,000 or to imprisonment for a term of 1 year or both. Is it the intent that that fine on indictment, that conviction on indictment is left up to the Grand Court? Or should we not be putting in a prescribed fine? Which should be higher than the summary conviction. But, or was it intended that the $5,000 was intended for the conviction on indictment? Because going about that, I don't think many people are going to reach that. But Mr. Speaker, just wanted all right, since it's unlimited, fine, the Grand Court, because it was 6 months imprisonment on it before. Yeah. Okay, Mr. Speaker, I just want this AG to understand, the Attorney General to understand that that was the basis on which I said under the Stalking law that nothing is going to be done. The provision was there and they did nothing. And they got to continue to do nothing. Thank you, Mr. Speaker.
Who wish to speak? The member from Newlands.
Thank you, Mr. Speaker, and I will be just as brief or even better. This is why in the previous debate I questioned why we had two regimes, because, and I'm going to try not to go over ground that my colleague has covered, but in terms of what I thought would have worked better would have been to secure a criminal conviction, which then opens the door to civil action. Because, for the same reason that the member from East End has pointed out, Mr. Speaker, it seems like an easy way to deal with this problem is for a police officer to say it's a civil matter, and it goes down that path. So that was my main concern with having both. Mr. Speaker, also in terms of the question on sentencing, we're on indictment, can be imprisoned for a term of 4 years, and in summary conviction, term of 1 year. I just had a concern. It may not be a big concern, however. We recently made changes to the penal code where if you had committed a summary offense along with an indictable offense, they could be joined together, sent to Grand Court. In that instance, Mr. Speaker, what then would happen is that automatically the punishment for what would have been a summary offense rises to 4 years. I don't know if that creates any sort of conflict where someone could later on appeal their sentence, and I don't think so. However, I just wanted to point that out, that it did cross my mind. Mr. Speaker, in terms of section 5 and 6, where this bill is giving the police increased power to arrest without warrant, to enter a premises without warrant, I am also very concerned in terms of giving, I would say, more power to the authorities without increasing the level of visibility, the level of accountability and responsibility. Anytime I think you tend to take action or put something in legislation that will take away from people's freedoms, in a sense, we need to ensure that those exercising that authority are prepared to make the right judgment, take the right action at the right time and under the right circumstances. This could be abused, and maybe not even intentionally, but by an officer of the law who is not properly trained in these sort of situations, especially where we're coming from a situation where we didn't have these criminal offenses, and now we're creating them. What I would like to see is some assurance that, Mr. Speaker, that we're going to engage in the requisite level of training so that the officers are prepared to deal with that added responsibility and added authority. Because that would concern me if we just simply made the change in the law and they continue to operate as they always have been. And we've heard examples where some officers have just chosen not to deal with it. So just those brief observations, Mr. Speaker. And again, I still support the bill, the changes, and welcome them. But hopefully the Honorable Attorney General will take my comments into consideration. Thank you.
Does any other member wish to speak? The member from Bordentown West.
Thank you, Mr. Speaker. First, I want to thank the government and the AG for bringing this bill. One of the things, as you look at Section 155 of the Penal Code, section has been repealed, you'll notice that is very vague. So I'm very happy to see that the definition of stalking is now being expanded, so much so that it's my hope that the police now, with a much broader definition, because the previous one was quite vague, which hopefully will allay the concerns of my colleague from East End, at least with a much broader definition, or that the police would be able to take more action. One of the things, Mr. Speaker, that I am concerned about from the penal code standpoint has been our issue where it's not about the laws, but rather the enforcement of the laws. And one of the things I would just like to consider, maybe this is something we can look at in the committee stage, is under the section where it deals with indictment that goes up to 4 years. I think at a minimum, it's important for us in this legislature to send a strong message where at least we believe it should be a minimum of 1 year service, as opposed to just putting 4 years. So one of the things that I am very mindful of, Mr. Speaker, and this is one of the things I think the public and everyone is sick and tired of, is people who commit these crimes and get these slap on the wrist, 6 months for this or 12 months for that kind of stuff. And I think it's important for us to send a very strong message that at least under Section 6A, if you're going to go to prison, you're going to go to you're going to serve at least a minimum of 12 months. I think that's one of the things that we should consider at the committee stage. In terms of Section 6B, Mr. Speaker, I'm happy to leave that with no minimum, for the simple fact, in terms of looking at how the law is written, I am very mindful of other people who have domestic issues, and as I read some of the definition, it occurs to me that if a woman or a man suspects that their spouse is cheating and decide to go stalk them and go, date himself and find himself committing a crime now, that was one of the things that my colleague from Eastern and I differed on, in that he believed that if someone is out, well, I won't even go there because maybe it's a different thing, but nonetheless, I think we should have some flexibility where husband, wives, or those stuff, because people do have problems in their marriages, and sometimes people kind of suffer mentally when they're going through marital issues. So I think we should have some flexibility in that regard. But I think at a minimum, Mr. Speaker, is that we should look at putting in some minimum sentences for those that actually are tried at the grand court level. And people know that if you do this to someone, you harass somebody, and you psychologically and physically harm them, you're going to be locked up for it. And I think that is the message that we in this legislature need to send to the public, that we take this issue serious, and there will be no slap in the wrist. Someone is going to go to jail for it. With that said, Mr. Speaker, that is just my contribution, but I just want to thank the government and the AG for bringing this piece of legislation, expanding the definition of stalking. I think this is something that is timely. It is something that is needed for many people in this country. And the only other thing I would ask is that the AG and the government consider giving the police the necessary tools from the ICT standpoint to make sure that they can track some of these issues. Because in this digital age where you can send something to WhatsApp and delete it within a minute and there's no trace of it left behind, those are things that are also worth considering. Now, I've spoken to the AG briefly during our last break concerning some of these stuff, and I know it's one of the things that he is keen on looking into. But outside of that, I would just ask my colleagues to just consider sending a very strong message that on the Section 6A, someone is going to go to jail for at least a year. There will be no 6-month sentence. There will be no 3 months. You're going to go to jail. Thank you.
Any other member wish to speak? Does any other member wish to speak? If not, I'll call on the Honorable AG to.
Mr. Speaker. Mr. Speaker, again, thanks to honorable members for their valuable contribution to the short companion bill, Mr. Speaker. Just to point out, as the member who just spoke quite rightly says, that one of the objects of this bill, Mr. Speaker, is that it broadens the range of conducts that would amount to stalking. Mr. Speaker, if you look at Section 155 of the current 155 of the Penal Code, the marginal note speaks to, could I crave indulgence? Yeah. The marginal notes, Mr. Speaker, speak to an offense of watching and besetting. And it basically says a person who watches or besets any premises or approaches to any premises with a view to preventing any person from doing any act which such person has a legal right to do, or B, if he watches or besets the house or other place where any other person resides or works or carry on business, prevent such person from doing so, commits an offense as liable for imprisonment for 6 months. So, Mr. Speaker, first of all, not creating any excuses for the police, but when they go to Section 155, the first thing they would see is nothing to do with stalking. It would be watching and besetting. Yeah. Watching and besetting, and invariably, Mr. Speaker, a number of the conduct that would be complained of would not be found in this current provision under Section 155, and hence the wisdom, if you will, of having this elaborate definition under the Penal Code bill. Right. But having said that, Mr. Speaker, I take the point made by the honourable member and also the last member who spoke about the reluctance of the police, for whatever reason, to prosecute these matters as stalking. And so what this bill will do is to remove any basis for any reluctance on the part of the police for getting involved in this matter as a criminal matter, as a criminal conduct. And so the police won't have that excuse available to them anymore. And certainly the Honourable Deputy Governor and myself have the benefit of being at the police briefing on a bi-weekly basis, and the Commissioner of Police is always in attendance. So we propose to speak to the Commissioner of Police and to sensitize him to the existence of this piece of legislation. And I must say, to his credit, we find that whenever you bring these things to his attention, he's the kind of person who tends to act right away and issues instructions about how to treat with them. So we propose to take that up with them, with him, and also, Mr. Speaker, to the point made by all three members who spoke about this, about the need for training for the police officers in order to be able to properly police this piece of legislation to address the growing issue of stalking. Finally, Mr. Speaker, I would prefer to have a more involved discussion about the issue of whether or not we need to put in a mandatory minimum sentence in this sort of thing. I understand the point the honourable member is making. We have not had the benefit of any consultation about this at all, and so we certainly will bear that in mind. But I would be sort of loath, subject to what the government thinks, to rush in now to put a minimum sentence in here without having the benefit of any sort of more in-depth discussion about that. including finding out from the Chief Justice whether he intends to issue sentencing guidelines to deal with these issues, with these matters and so. So I'll note it as something that has been mentioned by the honourable member, and bearing in mind, and we can have a more expansive discussion about, a more focused discussion rather, about the possibility of that going forward. Mr. Speaker, I'd like to thank the honourable member for this very passionate but very insightful discussion on these two bills, and I certainly value the contribution from that side and certainly from my colleagues on this side. And so, Mr. Speaker, with all of that, it's just for me to thank the Law Reform Commission, the Women's Professional Women's Club, Business Professional Women's Club, the Law Reform Commissioner and the department, the two directors of the Law Reform Commission, past and present, and all those who contributed to this exercise to bring these two bills to where we are today, hoping, Mr. Speaker, that the House will give them safe passage. Thank you.
The question is that a bill shortly entitled the Penal Code Amendment Number 2 Bill 2018 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Penal Code Amendment Number 2 Bill 2018 has been given a second reading. The House will suspend proceedings until 7:30.